Intellectual property law covers property rights over artistic and commercial assets. This can include musical and literary works, discoveries and inventions, words, phrases, symbols, and designs used in commerce. Essentially, the goal is to provide creators with an economic incentive to continue to develop their artistic endeavors. Success of events often depends on how much revenue they generate. There are two sources which are often tied to revenue generation and profit margin: tangible sources, which includes merchandise, tickets, and concessions, as well as intangible sources, such as player or team likenesses and names, sponsorships of events or facilities, and so forth. The Trademark Act of 1946, which is also known as the Lanham Act, governs the law of trademarks and their registration. Any word, name, symbol, or device that an organization uses to identify and distinguish its services from that of another organization and to indicate the source of the service is covered under the Lanham Act. The purpose of the act is to protect the owner of a mark by preventing others from using the mark without permission or in a way that will cause confusion. There are four primary functions of a trademark. The first is to identify a seller's goods and distinguish them from goods sold by others. It signifies that goods come from one particular source. A trademark also indicates that a product is of a certain quality. And then finally, a trademark advertises, promotes, and assists in selling the particular good. There are a number of different types of trademarks. Arbitrary or fanciful marks are inherently distinctive because they describe the source of a good and not the actual good itself, so the Nike swoosh is an example of that. Suggestive marks require some creativity to understand the product that they describe. Descriptive marks describe a characteristic or quality of a good or service. They're not necessarily protected under a trademark law. They need to show that the mark has a secondary meaning, aka that people recognize. For example, that purple and gold may only be associated with the LA Lakers. Generic marks are so common they cannot receive federal trademark protection. So when we think about gelatin-based desserts, people usually just call it Jell-O. Collective marks are used by members of a cooperative, association, or other collective organization to indicate membership in that organization. So the NBA, WNBA, Major League Baseball, Major League Soccer are all examples of collective marks. A service mark is used in the sale of advertising or services to identify and distinguish the services of one entity from services of another. So the NCAA can be a service mark because it stands for events and services related to the national championships and so on. Trademark infringement is defined as when someone who is not a trademark owner engages in some unauthorized use of the trademark with the intent to cause consumers to be confused about who really owns the trademark. There are a couple elements of a claim, meaning that an owner must actually use the trademark and must have it registered, and they also must demonstrate that the other party's use of the mark is likely to cause confusion or deceive customers about who is the true source of the trademark. There are several factors that determine infringement. The first is the strength of the mark, so how much people associate the trademark with the product. Similarity between the marks, so how closely they resemble each other, like EA Sports and this Energy Armor drink. And then finally, on this slide, the evidence of actual confusion. So you have to prove that the other mark makes people think about the original mark or product. Some additional factors on this slide are the quality of the alleged infringers of products. So if they are of worse quality, then that will impact the case. The similarity between the products, so how similar is Body Armor the drink and Under Armour the actual apparel. The likelihood that the person who owns the original trademark is going to expand into other areas. Like Under Armour ended up actually buying Body Armor so they could expand into the protein supplement drinks. And then whether the alleged infringer acted with good faith. So were they purposefully trying to deceive the public, or did they just think their trademark wasn't that close and that's why they used it? There are a few defenses when people are claiming trademark infringement. The first is fair use, so it's where a trademark is used fairly and in good faith only to describe the goods or services involved. So when you use a logo in the newscast or you talk about something in the newscast that's trademarked, but you really just are trying to describe the event. Artistic use is when, like for example, Andy Warhol's Campbell Soup paintings, or the picture on the last slide, which is a picture of Tiger Woods at the Masters. Tiger Woods sued that artist, and the artist's defense was that it was just an artistic creating of Tiger Woods at the tee. And then finally, licensing, which is essentially an agreement that the trademark holder makes with a second party so that they can basically use the trademark and they pay a fee to the trademark owner. Dilution is another aspect of trademark law, and this is the lessening of the capacity of a famous mark to identify and distinguish its goods or services. And this occurs through two things: blurring, which is when a second party uses or modifies a mark, which results in the weakening of the original mark to identify goods. So it's no longer clear that your mark is what it says it is, because if you look at these Starbucks logos, they're really similar, and so it takes away from your brand recognition, essentially. And then tarnishment is when the mark is used in association with unwholesome or shoddy goods and services. And basically it's saying when your trademark gets used in a way that is bad, it makes your product look bad also. Trademark protection can be denied if nicknames are seen as disparaging, deceptive, and scandalous. The Harjo case stated that Washington's NFL team uses a racial slur for their mascot, and as a result should not be allowed to be trademarked. The court sided with the defendants, Pro Football Inc., using the doctrine of lashes legal basis. So basically the doctrine of lashes says that the plaintiffs needed to sue in the proper amount of time, and they waited too long to say that it actually had a negative impact on people. As a result of some of this litigation, the NCAA banned Native American mascots, except at 3 institutions who have permission from the tribes to use them. Internet domain names are also protected by trademark law, although they've had to upgrade some of the laws because in 1946 the internet did not exist. So the first act outlaws cyber squatting, which is registering a domain name similar to someone else's registered trademark and demanding payment for the trademark holder to buy back that name. In addition, the Uniform Dispute Resolution process. The trademark owner must allege that its mark is identical or confusingly similar to the mark used by a cyber squatter, and that cyber squatter registered and used the domain name in bad faith. So basically what happened was, when the internet first started, a bunch of wise people bought a bunch of domain names that they thought organizations would want to buy, and then they essentially held those domain names hostage until organizations shelled out money. So these laws are designed to protect people that own the original trademarks, so they're not held hostage, so that people's websites don't confuse them if they're too close to the original trademark. Unlike trademark law, copyright law does not protect intangible ideas. It actually focuses on things that are like broadcasts, written word, or movies. So copyrights also give authors exclusive rights to publish, reproduce, and sell the product. Unauthorized use of copyrighted material in a way that violates one of the owner's exclusive rights in the copyright can be punished by fines and injunctions to try to stop people from using it. The chapter provides an extensive list of what is protected, some of which includes books, as I said, sound recordings, and movies. The chapter goes into a little bit of detail about how game accounts are handled under copyright law. So what it basically states is that teams own the rights to broadcasts. Players are employees of the club. They collectively bargain a percentage of revenue from media and broadcast rights so that they get a little bit of revenue back from being the product, essentially. The chapter also discussed the ways in which statistics have been subject to copyright law. In the NBA versus Motorola case, the court sided with Motorola, saying that the NBA did not have copyrights to statistics that occur during games because games are unpredictable. In contrast, the Morrison versus Communication versus PGA Tour case, the courts sided with the PGA Tour, saying that Morris was trying to capitalize on the PGA system and that Morris Communications didn't invest anything in the PGA system but tried to use the outcome to their advantage. In terms of intellectual property, the right of publicity is an important concept, and many states have recognized this right by common law or included it in state statutes. Essentially, it protects athletes and celebrities' marketable identities from misuse by others. It allows athletes and celebrities to control and profit from the use of their names, nicknames, licenses, portraits, performances, and so on. And two important lawsuits within this concept are Halen Laboratories versus Topps Chewing Gum in the 1950s, in which the court first recognized the right to publicity, a right of professional athletes to be able to control their own image or likeness. And more recently, Keller versus EA Sports, in which NCAA student athletes sued video game manufacturer EA Sports for their football and basketball games that used real student athletes, and then EA Sports kept all the money, so that Keller versus EA Sports are what caused EA Sports to stop producing those games. Right to publicity is important when we think about controlling your name, image, and likeness for NCAA student athletes. So in 2021, the Alston versus NCAA case basically paved the way for states to pass regulations regarding name, image, and likeness of student athletes, as it ruled that the NCAA was violating antitrust law, essentially. So student athletes can now profit from their name, image, and likeness, and various states have passed laws. Some are in the process of passing them, but there are some things to think about in terms of making sure that student athletes know what they're getting themselves into, because regulations vary by state. Some states, the laws apply to high school and higher ed. Some states, the law only applies to four-year universities, and some applies to 2- and 4-year universities. Some have really strict stipulations around what you can and cannot endorse. But again, intellectual property, it's important for the student athletes or people to be able to profit from their name, image, and likeness rather than having someone else profit off of them. Patent law gives the owner of an invention the right to exclude others from reproducing the patented invention for 20 years. It also gives the owner the right to stop others from copying their idea. An invention is patentable if it's a new and useful process, a machine, a manufacturing or a composition, or any new and useful improvement. Some examples of patents in sports are types of equipment used to play the sport, designs for apparel worn, so things like Nike Dry Fit. Certain games themselves, like the Arena Football League, owns a patent for that style of football. Ambush marketing is a situation where one company creates advertising or promotional campaigns that confuse consumers and wrongly imply that the company is an official sponsor of an event. Ambush marketing harms companies that are official sponsors who spend a lot of money sponsoring the events by weakening their relationships with the events. And it's usually found at large-scale events such as the Super Bowl or the Olympics. So, for example, NBC paid $775 million for TV rights to the Sochi Olympics, so they probably wouldn't want ESPN or ABC or CBS creeping around with signs and with people wearing t-shirts at official events, because people may be confused and not think NBC is an actual sponsor. A trademark protects names and logos. Copyrights protect things like likenesses and broadcasts, and patents protect inventors from other people creating a similar product. The goal of intellectual property laws are to protect artists and commercial assets and to provide creators with incentives to develop their work.